Indian Partnership Act and Limited Liability Partnership Act. Nature of partnership. Partnership is a relation between persons who have agreed to share the profits of a business, the business carried on by all or any of them while acting for all. Mere receipt of a share in the profits of a partnership firm doesn't make a person a partner by himself. To become a partner, one has to be a part of the partnership agreement. Parties to a partnership agreement are individually called partners and collectively they are called a firm. Firm name is the name under which the business of the partnership is carried on. Whether a person is a partner or not is decided by looking into the real relationship between the parties under the contract. As regards relation of partners to third parties, a partner is an agent of the firm for the purposes of the firm's business. The act of a partner binds the firm, and this authority to bind the firm as an agent is called implied authority. But the implied authority doesn't include right to submit a dispute to arbitration, open a firm's bank account, or relinquish any claim, or withdraw a suit filed in a court, or acquire or transfer immovable property on behalf of the firm. In a relationship of agency, any notice to a partner operates as a notice to the firm, except in case where fraud is involved by the partner. Every partner is liable jointly with other partners and also severally for all acts of the firm done while he is a partner, whereby the wrongful act or omission of a partner in the conduct of business, loss or injury is caused to any third party, both the partner and the firm jointly and severally liable to the third party. Where the contract between partners provides for the duration of partnership or the end point for determination of the partnership, such a partnership is called partnership for a fixed term. Where the contract of partnership doesn't provide for the duration of partnership or it doesn't indicate the point of determination of the partnership, and even where it specifies the duration, if the partners continue their business even after the duration, in both cases the partnership will be known as partnership at will. A partnership which is formed for a particular adventure or undertaking, and at the completion of the said venture or activity the partnership is dissolved, such a partnership is known as particular partnership. Where the scope of the business of a partnership is not defined and it is to carry out business in general, such a partnership is called general partnership. Partners, 5 types: working partner, sleeping partner, limited partner, partner in profits, and nominal partners. Contribution of capital comes from everyone except nominal partner. Participation in the management largely by the working partner. Partner in profits shares only profits. Nominal partner doesn't share profits or losses. The remaining 3 share profits or losses. Liability is limited in respect of limited partner. In all other cases, it is unlimited. To the outside world, partners who are known and visible are working partner and nominal partner. The mutual rights of partners is decided by the terms of partnership. For participation in the conduct of business, partners are not eligible for any remuneration. Unless the contract states otherwise, partners share both profits and losses equally. Where the partnership deed talks of interest on capital, such interest can be paid only when the partnership makes profits, as it has to be paid only out of profits of the firm. An interest of 6% per annum is payable to a partner who makes payment or advance beyond the amount of capital. He will also be indemnified for payments made or liabilities incurred, provided it is incurred in the proper conduct of business for protecting the firm from loss, and it was done under circumstances as would be done by a person of ordinary prudence. Although it is partners' right to participate in business, it all depends on the express or implied contract between the partners. In the normal course, a partnership may provide that a partner shall not carry on any business other than that of the firm. He has got a right to take part in the conduct of business. He is bound to attend diligently to his duties. Any difference in a business is decided by majority vote, and every partner has got a right to access and inspect and take a copy of the books of accounts. It's a duty of every partner to use the property of the firm exclusively for the purpose of the business. If he derives any profits for himself, he shall account and pay it to the firm. If he carries on a business competing with the firm, he shall pay to the firm all profits of that business. When a change happens in a firm and it is reconstituted, mutual rights of partners remains the same, and if a partnership firm continues after its duration, the mutual rights and duties of partners will be as if it is a partnership at will. Among the duties of partners, the general duty to carry on the business to the greatest common advantage, to be just and faithful to each other, and render true accounts and full information with transparency. For all losses caused to the firm due to fraud or negligence, a partner shall indemnify the firm. Section 30 deals with the minors and partnership. Minors may be admitted to the benefits of a partnership with the consent of all partners, but a minor cannot be a partner himself. He may have access to and inspect and take copies of any of the accounts of the firm. Minor's share is liable, but minor is not personally liable for any acts of the firm. On attaining majority within 6 months, he may give public notice that he has elected to become or not to become a partner. If he fails to give such notice, he becomes a partner on expiry of the said 6 months. On attaining majority when he becomes a partner, his rights and liabilities continue as a minor up to the date on which he becomes a partner. He becomes personally liable for all acts of the firm to third parties since he was admitted to the benefits. His share shall be the share to which he was entitled as a minor with no change. And where he elects not to become a partner, his rights and liabilities continue to be those of a minor up to the date of public notice, and he shall not be liable for any act of the firm done after the date of the notice. The office of the registrar of firms is relevant for formation of a partnership. Registrars are appointed by state governments and their areas are defined. An application for registration is submitted to the registrar along with the details of firm name, places of business, names and address of partners, and duration of the firm. Each person signing the statement will verify in the prescribed manner, and the firm name shall be in conformity with the approval of the registrar of firms. Once the registrar finds the application to be in conformity with section 58, he will record an entry in the register and the firm is registered, and it is the duty of the firm to file alterations subsequent to registration, be it in firm name, place of business, branches, or names and addresses of partners, or anything pertaining to dissolution of the firm. Non-registration of a firm creates disabilities for the firm and its partners. Where a firm is not registered, no suit can be filed on behalf of a partner against the firm or other partners, and also on behalf of the firm, no suit can be filed against any third party, but non-registration will not affect the right of a partner to sue for dissolution or to sue for accounts of a dissolved firm or to realize property of an insolvent partner. Under reconstitution, there can be admission of a partner subject to consent of all existing partners and the new partner liable for acts done after he became a partner. Retirement is permitted with the consent of all partners or as per the express agreement by the partners, or where the partnership is at will by giving a notice in writing to all partners of his intention to retire, but he continues to be liable to third parties for any act done till his public notice is published. Reconstitution includes expulsion of a partner in good faith and in terms of powers confirmed by contract. An expelled partner will be covered by section 32 as if he is a retired partner. In respect of insolvency of a partner, he ceases to be a partner on the date adjudicated as insolvent, but his estate not liable for acts done after that date. In respect of a deceased partner, his estate will not be liable for acts done after the date of demise. An outgoing partner, be it retiring partner or an expelled partner, can carry on a competing business, but he shouldn't use the firm name or solicit business from persons dealing with the firm. The firm can enter into an agreement with him not to carry on similar business within a specified period or specified area, provided the restrictions are reasonable. If he has given a continuing guarantee, it shall be revoked as to future transactions. And the continuing partners, if they carry on business without final settlement of the outgoing partner, the outgoing partner is entitled to his share of profits attributable to the property belonging to him in the firm, or he is eligible for interest at the rate of 6% per annum. Dissolution of a partnership is permitted by agreement when with the consent of all partners it can be dissolved, or it is required to be dissolved compulsorily when all but one or all partners are adjudged insolvent, or the business of the firm is rendered unlawful on the happening of any event. And other than this compulsory dissolution, if it is a partnership at will, it can be dissolved by way of notice from one of the partners, giving a notice in writing of his intention to dissolve, and the dissolution take place based on the date indicated in the notice, if date is not indicated, from the date of submission of the notice. Under section 44, court can dissolve a firm on various grounds. One of the grounds is a partner has become of unsound mind, or a partner has become incapable of performing his duties on a permanent basis, or a partner is guilty of conduct which is likely to prejudicially affect the conduct of business, or a partner willfully commits breach of agreements and it is not practicable to carry on business anymore, or the business of the firm cannot be carried on except at a loss or any other just and equitable basis, the court is convinced that the firm should be dissolved. Under normal circumstances, dissolution also takes place in respect of partnership for a specific period by the expiry of that period, in respect of a partnership for a particular adventure on the completion of that adventure, or by the death of a partner, or by the adjudication of a partner as an insolvent, all these in the normal course. Even after dissolution, partners continue to be liable to third parties until public notice is issued. Partners are entitled to have the business wound up, pay the debts and liabilities, and get the surplus distributed among themselves. The property of any partner is first applied in payment of his personal debts. Surplus only will be available for payment of firm's debts, and the firm's priority will be losses paid out of profits, then out of capital, and lastly by contribution from partners in the profit sharing ratio. Assets of the firm are distributed in the order of debts of the firm to third parties, followed by return of advances from partners, then return of capital, and if residual surplus comes, it will be distributed to partners in the profit sharing ratio. Section 54 provides that the partners, upon dissolution or in anticipation of dissolution, can make an agreement that some or all of them will not carry on a business similar to that of the firm within a specified period or within a specified local limits, and such agreement shall be valid if the restrictions imposed are reasonable. This is notwithstanding anything contained in section 27 of the Indian Contract Act on contracts in restraint of trade. Limited Liability Partnership Act. The concept of LLP, Limited Liability Partnership, gives the flexibility of a partnership and a separate legal entity. It is a partnership formed under LLP Act, which defines mutual rights of LLP and partners. The number of members required to form an LLP, minimum 2. They can be individuals, LLPs and a company, but members cannot be cooperative society or any other body corporates. LLP Act provides for designated partners who are responsible for ensuring compliances. They should be individuals. 2 designated partners are required. may include representatives of body corporate. At least one of them should stay in India for a minimum of 120 days during a financial year. The consent of a DP is filed in Form 9 and particulars of a designated partner are filed in Form 4. Foreign LLP is one which is registered outside India but having a place of business in India. It is required to state legibly in all its invoices and correspondence that it happens to be a foreign LLP. The first step in the incorporation is reservation of name, which will be reserved if available up to 3 months after intimation by the registrar, and during the period submission of incorporation documents with the details of 2 or more subscribers furnished with the capital based fee payment for certificate with the LLP in issued within 14 days. Details of registered office also submitted as address for all communications. As an effect of registration, an LLP becomes eligible to sue and be sued. It can acquire and dispose property in its own name, and it can act as a body corporate using its common seal. And its name could be changed with the consent of requisite members, or when the government directs the name to be changed, it has to be done within 3 months. On change of name, fresh certificate will be issued and the new details has to be used in all subsequent correspondence. LLPs have the privilege of changing their registered office within the territory of the registrar or within the state or interstate. There is a requirement of 21 days notice in a vernacular and English daily, more particularly in respect of interstate movement. Consent of secured creditors required to be obtained, and also filing with the necessary details required to be done at registrar within a period of 30 days. An agreement between subscribers defines the relationship between partners. It has to be ratified by all partners within 30 days of incorporation and filed 30 days thereafter. Any changes also to be filed within a period of 30 days. If there is no agreement formally filed, first schedule to the Act applies. As for liability, cessation of partnership interest can happen as per agreement, or it can be on the death of a partner, or on dissolution of LLP, or based on a court order in the event of insolvency or unsound mind. As regards entitlement of an outgoing partner, he will get proportionate capital, accumulated profits net of losses, and a share in profit or loss till the notice of ceasing to be a partner. As regards the change in partners and their particulars, names and addresses change. Partners have to indicate LLP in 15 days and LLP to inform registrar within next 30 days. And outgoing partners and new partners can inform registrar directly, or they can inform through the LLP. For all acts supported by authority in the course of business, the liability will be that of the LLP. Every partner as an agent will however be liable for any wrongful acts or any acts to defraud creditors, and every partner is required to contribute as per LLP agreement. LLP to maintain books and accounts for every year on receipts, expenditure, assets and liabilities, books to be preserved for 8 years from year end, a statement of account and solvency to be signed by designated partners, and the same to be filed within 30 days after 6 months of year end, and the statement of account and solvency is available for public inspection. Statutory audit is mandatory where the annual turnover exceeds rupees 40 lakhs or the contribution from partners exceeds rupees 25 lakhs. Auditors are to be appointed 30 days before the year end. Regarding appointment and removal, LLP agreement provides for the process and its requirement. Any resignation and the resulting casual vacancy to be handled as per the provisions of LLP agreement. Annual return of an LLP needs certification by a company secretary where the turnover exceeds rupees 5 crore or contribution exceeds rupees 50 lakhs. The return will be signed by designated partners and will be available for public inspection. Incorporation documents, LLP agreement and notice of situation are records to be preserved permanently. In respect of liquidation accounts, preservation is required for 21 years and other papers have varying durations as specified in the Act. Registrar of Companies has exhaustive powers to summon and seek details from designated partners and employees, both past and present, on various requirements as regards an LLP. An existing partnership firm can be converted, taking all the existing partners into the LLP and transferring the whole of assets and liabilities. The firm has to apply to registrar with all incorporation documents and statements pertaining to the partners. Any refusal at the registrar can be appealed against with the company law tribunal. The conversion of a private limited company into LLP is similar to that used for converting a firm into an LLP, involving incorporation documents and statements by all shareholders. Only requirement, it has to take all shareholders as the partners of LLP. Conversion into an LLP is also permitted in respect of unlisted public limited company. The public limited company has to take all shareholders as partners in the LLP and submit all incorporation documents and statements required from all shareholders. The converting entity has to inform the relevant registrar of companies within 15 days that all property and the whole undertaking vests in the newly formed limited liability partnership and the erstwhile entity is dissolved and removed from the registrar of firms or companies as applicable. All pending proceedings shall be continued by or against the limited liability partnership. Conviction, ruling, judgment as applicable shall be enforced against the LLP. 12 months from registration, every correspondence from the entity formed after conversion, inserting the words converted into LLP from indicating the name and registration number. A voluntary winding up of LLP starts with the resolution passed by partners, obtaining approval of creditors, followed by declaration of solvency duly signed by the DPs and publication of newspaper notice to the effect of proposal to dissolve. A liquidator is appointed. The report of the liquidator to partners and creditors will be presented for approval of 2/3 majority within 30 days. The winding up report will be filed with the registrar within 15 days of completion. Thereafter, the LLP will apply to the tribunal to order the dissolution. Once LLP receives the tribunal order, the same shall be filed with the registrar within 30 days. The registrar's gazette notification in the matter finally dissolves the LLP. In the course of winding up, the LLP liquidator has to file disclosure of conflict of interest on an ongoing basis at every stage of the assignment. He may be removed by the tribunal on application from the registrar or by the appointing partners or creditors after due process of notice and hearing. The liquidator shall maintain, register and proper books of account, and the same shall be audited periodically. And the liquidator may include the views of partners, designated persons in his report submitted to the tribunal. Winding up by tribunal takes form based on a petition from LLP or its partners or the creditors. The registrar obtains central government approval as the company is unable to pay based on declaration of solvency all its liabilities. Objections from the LLP is solicited at this stage, and this is followed by appointment of liquidator, who is required to give the report within 60 days and follow it up by taking custody of assets and proceeds. The tribunal can decide on appointing a sale committee or take action for rehabilitation of the LLP. Periodical reports of liquidator are filed with the registrar. On completion of winding up, liquidator's report to LLP after approval is filed with the registrar. LLP also applies to National Company Law Tribunal to order its dissolution. LLP stands dissolved once winding up tribunal order is filed with the registrar. Anyone aggrieved with the dissolution may appeal to National Company Law Appellate Tribunal within 45 days of the winding up order.